I wanted to chat a little bit about determining legislative intent and the role of the California courts. When they look at the intent of the legislature, their intent in enacting a particular state statute, the California courts have historically taken a limited view of legislative materials that can be used to determine intent. And the courts generally rely upon certain types of legislative history documents to gain their understanding of the meaning of a statute, and then ultimately to try and determine how to apply the legislature's intent when interpreting a statute. The determination of legislative intent is very important because there are instances in which there are legitimate legal disputes between two parties as to what particular statutory language may mean or not mean, or ultimately what was intended by the language of that statute. In these cases, the parties attempt to argue that their interpretation of the law is the correct one that should be adopted by the reviewing court. And then obviously it's up to the state judiciary to determine whose view is going to be deemed the correct one. The concern that I have is that our state courts utilize what I view as an unrealistic viewpoint in determining which legislative history and intent materials can be properly used by a court to help make that determination. For example, the courts have consistently ruled that documents available to all legislators are really the proper ones to use. Now, this idea of limiting it to that is based upon the assumption, which may not always be correct, that all legislators read all of the materials available to them before casting their vote on a bill that enacts a statute. I say it's an unlikely assumption because it's not realistic in terms of what actually happens in the legislative process. Now, that is not in any way a criticism of the legislature or certainly of any individual legislators. I think it's really just simply an acknowledgement that legislators can't be expected to read every line of every bill and every line of every piece of legislative documentation, the committee analyses and the floor analyses and other background materials, and really thoroughly understand the intent behind each and every measure and why particular wording was used in that bill that became a statute when they're voting on literally thousands of bills each and every year of the session. I think it also assumes, of course, that everyone votes for whatever information is based upon those materials like committee and floor analyses. Now, again, realistically, for those involved in the legislative process, we know that there are many different reasons, many different factors that can influence why a legislator may vote for a particular bill. The other thing that I view is that legislative history in the state of California, especially when you compare it to a lot of the verbatim transcripts, for example, and other more detailed information that's produced by the Congress, is that a lot of insights are not provided as to the actual bill language and therefore the statutory language. Now, this is not a criticism of the legislature or our process. It certainly is not a criticism of those who read, analyze, and write these detailed analyses about measures in committee and on the floor. Instead, it's, I think, an acknowledgement that there's a limited amount of time and that a lot of the material produced in conjunction with considering legislation in California is not detailed related to the language of the bill. In other words, there's plenty of information related to what the bill does and the arguments pro and con, Now, this is different from like Congress, where they'll take testimony and then at a usually a separate session, the committee does a markup where they really delve more deeply into the legislative language being used, and they can discuss it and debate it. And of course, there are transcripts of those hearings. Now, in California, the legislature is required to video and audio tape, but there isn't written documentation like the congressional record. Um, Again, in the California legislature, like with a number of states, the standing committees rarely get into the details of bill language. Instead, uh, in litigation, the debate is over the actual language. In the legislative process, the debate is generally over the policy, or at least the stated policy of a particular bill, but rarely is there open and robust discussion about the language used. So again, at the federal level, they have the benefit of the congressional record. In California, our Assembly Daily Journal and Senate Daily Journal don't have much in the way of details regarding legislative debate on the floor or in committees. And so really the main source of legislative intent in the California legislature that the courts turn to are the committee and floor analyses. And as I've mentioned, I think they don't provide detail into why specific bill language was not or was used in developing the statute. Again, they're focused on explaining what is existing law, what are the proposed changes to the law being made by that bill that they're analyzing, what are the author statements, what are the arguments of the proponents for the bill, what are the arguments of the opponents against the bill, and some of them offer very helpful or insightful staff comments. But again, they rarely discuss specific language and why particular language was used. And so there's a limited amount of information to glean when the courts review these analyses. So the California courts' reliance on certain legislative materials is clearly important to know. But again, I think that our state courts may be taking an unnecessarily narrow view of which items are appropriate to be used in determining the intent of the legislature in enacting a particular statute. And so when they make these determinations about which documents are properly considered by a court, there is not really a clear understanding of the legislative process. And I think there's a lack of familiarity with the process and who or what are the best sources of accurate statements of legislative intent. And I think one of those should be statements by the author of a measure. The reality is in California and a number of other states, the legal world is becoming much more dominated by statutes rather than court decisions. And it's really of increasing importance in my mind for the courts of this state to understand the legislative process, to utilize all of the right forms of legislative history and possible evidence of intent to give the best interpretation of ambiguous or vague statutes. And, it's an unfortunate reality that sometimes statutes aren't as clear as they could or should be, and that there are legal disputes as a result. But as much as we like to say, just follow the statute's plain reading, at other times, the courts are going to have to look for evidence of the legislature's intent. And I think in that regard, greater consideration should be given to statements made by the authors of particular pieces of legislation.